Can I apologise to you for starting your session a little bit later than we had anticipated? It does mean we will finish a little bit later than we had anticipated, but that is as it is. So thank you very much. Ms. Richards.
So I think the first.
I think we need to swear you first.
Please state your full name.
James Yalmar Renegund.
And read from the prompt.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Mr. Quinault, you're the Director General in the Cabinet Office, responsible to the Minister for work on the government's response to the infected blood inquiry, including work on designing and drafting legislation for the compensation scheme. I think that's a correct description of your role.
That is correct, yes.
Does this mean that you're the most senior civil servant in the Cabinet Office with oversight and responsibility from the civil service perspective for the compensation scheme?
Yes, that's correct.
And do you report to the Minister directly or to the Cabinet Secretary?
I report to the Permanent Secretary of the Cabinet Office, Kat Little, and through her to the Minister for the Cabinet Office. In practice and for day-to-day work on this, I report directly to the Minister.
And you took up that position in June 2023?
Yes.
So you were in post, albeit pretty new in post, when the inquiry held its July 2023 hearings and heard from the then Prime Minister, then Chancellor, and then Paymaster General?
Yes, I was in post.
And what's the precise role of you and your team in the design and drafting of the regulations for the scheme?
So my team does not directly draft the regulation. That is a job done by professional legal draftsmen and women. It's a complicated business and needs to be done by professionals. But my team will instruct them, will tell them what the policy intent is as decided by the Minister and help them to translate that into good law.
Now, I'm going to start with questions which relate to the period from June 2023 to July 2024 when the new government came in. So I'm going to start with that period. I'm not going to ask you about earlier when you were not in post, but that period under the previous government. You will know that this inquiry recommended in April 2023 a scheme that is completely independent of government. And as I think has been universally acknowledged in the hearings so far, the scheme which we have is not completely or even remotely independent of government because the scheme has been designed and the tariff set by government. That's right, isn't it?
That is true. The scheme is as set out in the regulations which are passed by government.
And the scheme draws heavily on the advice of the expert group, and that was again not as recommended by this inquiry.
No, this inquiry recommended that the body administering the scheme itself should set the terms of the scheme.
Now, who is it who made the decision to have a scheme in which the design and structure of that scheme, the criteria for eligibility and the tariffs, everything we now see set out in the regulations, was solely determined by government?
That decision had already been taken by the time I took up my post and was a decision taken by the government at the time, and ministers, taken in principle at least, and ministers in their statements to Parliament thereafter made clear that they were going to be unlikely to accept the inquiry's recommendation on that point.
So by June 2023, the internal position within government, and I'm not going to try and check what the position was, what was being said externally, I can do that separately, but the internal position was that ministers, and it's a ministerial decision, had decided that it was going to be, as it were, a government-created scheme.
I don't know if they'd gone as far as that, but they had decided that the scheme would not be administered by a body wholly independent, reporting directly to Parliament and not through ministers. That had, I think, been decided in principle by that point.
And do you know conscious as I am from what you've told us that you were therefore not directly involved in that in principle decision, but do you know why that decision was taken?
Yes, I think I can say from what was subsequently discussed, ministers felt that for a scheme of this size, with the stewardship of this amount of public money, it'd be completely unprecedented to have that run by a body reporting directly to Parliament, rather than through ministers and subject to the principles of managing public money. There are bodies that report directly to Parliament, but they tend to be small ones and mostly associated with parliamentary affairs. There's never been, as far as I'm aware, any kind of body or scheme run in that way of this size before.
Now, in terms of panels, if one leaves aside the question of who the panel or panels would report to, because it would logically follow from the decision you've described, perhaps that they would report to government, which is what happened, rather than to the new body. What we didn't have is a legal panel and a clinical panel. We had a single expert group. Who took the decision to establish an expert group in that format, and approximately when?
So I think that decision was taken around about October of 2023. But it's worth saying that I don't think the government saw that expert group playing exactly the role that the panels would have done in an independent scheme. I think what the government wanted from the expert group at that point was advice to it about what a scheme might look like, how you might set tariff bands, what eligibility criteria it might be reasonable to set for them, and so on. So it could then make decisions about what the scheme should look like and could consult on those once it had done so.
How was the membership of that expert group arrived at? Do you know?
So having decided that the government needed expert advice in order to be able to make proposals about tariff bands, eligibility criteria and the like, it sought advice from the Department of Health and others about who would be best placed to give that advice. A short list of people with the right expertise was drawn up, and then ministers have made appointments from that.
Now, I know, as you've described, what was envisaged was a panel playing a different role from the role that had been recommended by this inquiry. But nonetheless, it's a role that would ultimately have a similar outcome, because it would be a role providing the input to enable the tariffs to be and bands to be created. This inquiry had recommended that it should at least include someone with psychosocial expertise, a clinician specialising in the treatment of people with bleeding disorders, a clinician specialising in transfusion. We see none of those three specialities within the expert group as established. Whose decision was that, and why?
So ministers took the decision about who to appoint to the group, but it's worth saying that, as I say, I don't think they saw this expert group playing quite the same role, as it were, making all of the decisions for their ratification about how the scheme should work. Instead, this is supposed to be about giving advice about what a scheme could look like, so that the government could then make proposals on that.
With the exception of the identity of the chair, the constitution of the expert group was initially kept secret for a period of time, which, as you will appreciate, further fuels distrust and concern. Why were their identities kept secret?
I do understand that that would have fueled further concern looking back. The reason why their identities were not published straight away is because, as I say, the government expected them to give it advice about what the terms of a scheme might look like. It was not expecting them to settle those terms or to consult with others about them, and thought that it would be unfair to expect people to give that advice and, as it were, to have to justify it in public before they'd even given it. So the decision was actually in order to help the members of of the committee rather than in order to keep this secret from others.
But was there an element of the government distrusting the infected and affected community with the knowledge of who was providing that advice? Or was it a government convention not to identify people?
The motivation was not to oblige people giving this advice to have to sort of justify that as they went. Several of the people on the committee are frontline clinicians treating people in the community. I think the government thought it would be unfair to expect them to have to account for that advice in public, as I say, before they'd even given it.
Why was the expert group not permitted under their terms of reference to discuss matters directly with people infected and affected?
So I don't think the terms of reference forbade them to discuss it with anyone, but there was a confidentiality requirement in there. And as Sir Jonathan Montgomery said when they tendered their advice, the practical effect of those terms of reference was to mean that they couldn't take views from the community properly. The intention, as I say, was not that this advice determine all of the terms of the scheme. The government intended to propose those themselves and then to consult on them. This was advice to the government to help it make decisions in principle about what sort of scheme it should propose.
But wouldn't the advice be better if informed by engagement with people who have the very lived experience of being infected for decades?
So it is clear that the scheme as a whole will be better if informed by that, but at the time the purpose of this was to give a government consideration of what a scheme might look like, what it would propose, more expert input than it had had up to that point.
Now, the second panel recommended by this inquiry had been a panel of lawyers, drawing on lawyers with expertise in how the courts approach the quantification of claims where people have suffered injury. It's inherent in the suggestion that the expectation was you would have more than one, and perhaps a strong exhortation to invite or make available the opportunity to participate to the lawyers who know those infected and affected better than any other legal firm will. That wasn't done. What was done was the appointment to the expert group of a single firm of lawyers. And I think it's right to say, and this is not intended as a criticism in any respect whatsoever, but lawyers whose work predominantly in this field is advising and defending NHS organisations and entities. And so, as I said, that's not a criticism of them, but a note of surprise, perhaps, that that's what the government saw as the most appropriate route.
The reason why that firm was chosen was actually a much more straightforward thing, which is that the government wanted to act quickly, needed this advice quickly to move on. For contractual reasons, it was far quicker to hire one of the firms already on the framework for the provision of this sort of advice. Doing so would have meant that they could be in position in 6 weeks rather than much longer if a new contract had to be let, and that is why Brown Jacobson were selected. The government was confident that they had, the right expertise to be able to provide advice on this, and also importantly could draw on knowledge of all 4 jurisdictions, which is important.
The process, whatever the reasons for it, the process that was adopted by the government was the opposite of transparent, wasn't it?
It was not the process that the inquiry had recommended.
It was not transparent, was it?
It was, as had this been a sort of public consultation, no, it wouldn't have been transparent. That is true.
And wasn't inclusive, and it did the opposite of putting infected and affected people at the heart of the scheme.
So I must acknowledge that last point. It is clear from how people have felt about it that they didn't feel that this was engendering trust or putting them at the heart of things.
May I just ask a question? Your answer that had this been a sort of public consultation, it would not have been transparent. When the current government talks about openness and transparency, is it talking just about public consultations?
No. No, of course not. And I'm sorry if I said the wrong thing. What I was trying to say was that this is not intended by the government to stand in place of the process recommended by the inquiry. It was a different thing, which was about getting it some advice about what to inform decisions in principle about what kind of scheme to propose.
But it's the very opposite of what was recommended by the inquiry in terms of the idea of placing the people damaged for decades in part by the actions of government at the heart of the process. It excluded them from the process.
It wasn't intended to exclude them. The government intended to consult on its proposals, but certainly it in no way could stand in place of what the inquiry recommended.
You've said the role of the expert group as envisaged by government was to advise the government, and it would then be for the government to decide what to do. What were the respective roles and responsibilities of the expert group and the Cabinet Office of Government in that process? Because we will perhaps see this when we come to the issue of the special category mechanism and its equivalents, but quite a lot of what the expert group advises, we do then seem to see translated into the scheme. What independent thought did the Cabinet Office bring to bear? Did it reject anything that the expert group had recommended?
I can't remember anything that ministers rejected that the expert group recommended, but their role was to provide expert advice to inform what things the government then proposed to people.
You say that it was the intention to consult on the scheme. We know that what actually happened was a very compressed period in June 2024 when Sir Robert Francis no doubt did his best within a very limited time frame and made clear in his report the constraints of that time frame. That in part was dictated by the decision to call the general election. When the government, prior to May of 2024, was planning what to do, what kind of consultation exercise did it have in mind? So
it's hard to say now how things would have been different, but I think originally, I think the intention would have been to bring forward proposals after the inquiry had published its final report, which back in October the government assumed would be March, then to consult on those proposals and then to put them into legislation in a bill to come forward in the next session. But of course, as things turned out, all of that timescale was truncated, first by the amendment to the Victims and Prisoners Bill, setting a deadline for the bringing forward the setting up of the authority, and then by the decision to call the general election.
Just picking up on something you said a moment or two ago, what you said reflects what we understood the government's position to be, certainly when we had our hearings in July 2023, that it was necessary to await the outcome of the final report. What actually was obviously happening during that period of time was the work that we now know was being undertaken by the expert group, by government, such that there was this ready-made proposal on the 21st of May. Now, I'm sure people within the Cabinet Office have looked at the full inquiry report, but it would stretch anyone's credulity to believe that on the 20th of May, or even in the few days before that, in terms of the advanced provision of the report to the ministers, or as is required under the Act, someone had sat down, read through all 7 volumes, and said, right, now we know we need to put this scheme into effect. Why was the government's position, and I accept it's not your decision, it's a ministerial decision, let me make that clear. Why was it the government's position that they needed to wait for the outcome of the final report?
So the government's position, as set out by ministers of the day to this inquiry, was that it needed to wait for that final report to give it the context into which it would be proposing a scheme, even though, as the inquiry had made plain, you'd already made all the recommendations you intended to make on compensation in the second interim report in April. I think when the government expected the inquiry to report in March, I think, though it is now hard to say, that there would have been a longer period before it had brought forward its response. But by May, I think ministers felt at that point that though they now had to wait for the final report because there was too little time left to do anything else, that thereafter they needed to act as quickly as possible because not to do so would leave even less time for people to consider the government's proposals before they had to be written into the law by the deadline that was now in the Act.
Many have expressed the view to the inquiry that they feel that they were misled by the government when it said that it needed to wait for the final report. Is that something you have any observations you would like to make on?
I think that is something you would need to put to ministers of the day, but what I can say is that I don't think it would be fair to say that the government said that in order to temporise or to put off the moment at which it would need to respond. It was, ministers were instructing us at the time to get on with work to prepare proposals.
I'm going to turn now to some aspects of the scheme as it now is. I'm not going to ask you about some of the detailed events from the new government taking over because we've heard from the minister yesterday afternoon. But given your close involvement with the development of the scheme, I'm hoping you can assist with a number of matters relating to it. The first question I want to ask is about the severity bandings for hepatitis C, which you know has caused considerable concern and arguably may make the process of paying compensation slower because of their complexity and what has to be evidenced at every stage. What account does the Cabinet Office say those tariffs and bandings take of the multiple effects of hepatitis C that are not related to liver damage, the extra hepatic manifestations?
So the intention is that those tariff bands do cover the commoner manifestations of those things. Obviously, if for rare and more serious conditions, there is the severe health conditions supplementary route. But the intent is that those bans should compensate people for the commoner extrahepatic manifestations of hepatitis. That was what the government intended that they should do. An example of that, if it helps, is that that is one of the reasons why the assumption for financial loss built into the chronic band, that assumption of financial loss begins from the moment of infection. It assumes that even before people see serious liver damage, that there will be an impact on them, and through that their ability, for example, to work. So it's certainly the intent that not all of this starts at the point at which serious liver damage develops.
And if we as an inquiry or those infected and affected who obviously have the absolute and primary entitlement to understand the scheme, if we want to satisfy ourselves of whether, and if so how, those consequences and effects have been considered and are built in, is there anything beyond the expert group's reports that assists in our understanding, or do we have to look to those expert group reports?
So the expert group reports are the place where understanding is assisted.
Want to ask about how the recognition of treatment with interferon factors into that. This inquiry heard comprehensive expert evidence. It heard comprehensive and frankly haunting testimony from individuals about the consequences, not for everybody, but for many, some life-changing consequences of treatment with interferon or interferon ribavirin. You say in your statement that the impacts of treatment are either covered by the core awards or eligible for the severe health condition supplementary route. Now, interferon clearly isn't eligible for the supplementary health route unless you are in the severe mental health psychiatric condition route. I just want to...
Sorry, just on that, yeah. I believe there can be, rarely, but unfortunately some other impacts of interferon beyond severe psychiatric impacts. I believe there can be impacts on, permanent impacts on the immune system in some cases. So at least I understand from the expert advice we had and from reading papers submitted to the inquiry. So I think that is picked up in the severe health condition
yes.
award as well.
Forgive me, it was slightly clumsily expressed by me. The severe health condition award identifies a small number of very rare health conditions, and then in the case of mental health damage, it identifies a category which is an identifiable psychiatric condition which has to be diagnosed by a psychiatrist and result in either inpatient treatment or 6 months at least of consultant-led treatment. But that will not capture, I can tell you as a matter of fact, that will not capture much of what we heard about the impact of interferon. And so the only place we could then look is the core award to see if that's captured. But the problem, and if I've misunderstood the regulations, please tell me, but people who were treated with interferon and had those appalling consequences will receive the same core awards as people who didn't receive interferon at all, or were in that's minority who received it and it was effective. So I don't see how it can be accommodated within the core award at present.
So the core awards are intended to cover the broad range, both people who had those impacts and those who were lucky enough not to. And it's intended to be set at a level which covers both. I referred earlier to the fact that the assumption in that chronic band is that the impact on people's ability to work, for example, starts right from infection, doesn't doesn't occur later. And that the intent there is, without asking people to bring forward evidence for how badly they were affected by interferon, to see that they're broadly compensated for it. And then for those even more unlucky to be severely and permanently get a severe permanent condition because of this, there is the severe health impacts route to pick that up. So that's the intention.
Well, and this inquiry will obviously need to consider whether that intention has actually been carried through. We looked yesterday with the Minister at matters relating to the special category mechanism and its equivalents in the other schemes. So I'm just going to say SCM to make the process quicker. The position, as I understand it, both from the documents and from the evidence yesterday, is that as at August of last year, the government accepted the advice of Sir Robert Francis and the advice of the expert group, which in this respect at least was squarely based upon feedback from infected and affected people through the June process, to include within the scheme health impacts which reflected for both hepatitis C and B those that were hitherto covered by the SCM. That's correct as a statement of fact, isn't it?
The government did accept, as the Minister said, that there should be a route for people with especially severe impacts to get that recognised in the scheme.
But importantly, the government accepted that those, as well as listing a number of rare and absolutely severe conditions, the government accepted, and we can see it in the annexes to what the government published on the 23rd of August 2024, it includes the criteria drawn from the national schemes.
That is true. The advice of the expert group on this was ambiguous, as it turns out. That report both says that this ban should cover all of the impacts reflected in the SCM, but also it says elsewhere that some of those impacts are already reflected in the core route. So that advice was ambiguous.
Well, we may need to ask you, Mr. Quinault, and I'm not going to ask you to do it now, to identify for us in a further statement how and why it's said that those ambiguities arise, because I certainly haven't read it as anything other than clear advice.
May I just ask this question? You say that the advice from the expert group was ambiguous. There was, as I understand it, no ambiguity at the time about the government's acceptance of the need for something in between.
What the recommendation of Sir Robert Francis was that the government should accept the advice of the expert group. It was that the advice of the expert group should be followed, and the government accepted that. As it turned out, that advice on this point turned out to be ambiguous. But in answer to your general point, I acknowledge completely that anyone reading the section of that section of the expert group's report, together with what the government and Sir Robert had said, would have assumed that this meant that everything in the current SCM would be would count.
They'd have assumed that because that's what it said in terms in the government's 23rd of August publication.
So what that said was that there would be a severe health impacts route. Yes.
Well, I'm not going to debate the wording of documents with you now, Mr. Quinault, but we will be carefully scrutinising those line by line. When the Minister stood up in Parliament on the 2nd of September, and I should add I'm not seeking to trespass upon parliamentary privilege here, when he stood up in Parliament and said, I have accepted 69 of the 74 recommendations, one of those 69 was the recommendation that the SCM and its equivalent criteria would be part of the scheme, is it not? Sorry, we don't pick up nods on the...
Sorry, I beg your pardon. the government was accepting Sir Robert's recommendation that the advice of the expert group be followed.
On this specific issue. Now, we know the position has changed, and I want to try and understand how that happened. And here I do need to look at a document with you. It's WITN 7762.015. And this is the further report of the expert group from, I think, published on the 12th of February this year. Can we go, and I'm hoping I'm going to get the right pages this time, Lawrence, bottom of page 4. I'm hoping this should be the heading. Introduction, excellent. Good start. Next page, please. First paragraph on the next page. It says here, this is the group speaking. We revised our initial advice in a number of respects based on the feedback from the engagement events convened by Sir Robert Francis. This revised advice was set out in our final report. Following their acceptance of the recommendations made by Sir Robert Francis, we were invited by the government to provide further detailed advice on 3 issues in order to assist with the drawing up of the scheme. We've been pleased to have the opportunity to consider these issues further, which we've done in light of the engagement meetings held by Sir Robert. And then we can see the 3 issues then set out, if we just go back. So we can see the first is supplementary severe health condition awards. So it would appear that by the time of this further instruction to the expert group, the government had decided it wanted further advice on this issue. Having accepted its previous recommendation, having drawn up the scheme that was published on the 23rd of August, why did the government go back and ask for further advice on this issue?
I don't think this is a subsequent decision. The government said in that 23rd of August document that further work would be done on the severe health condition route. This was the further work. So I don't think there wasn't a change of mind in terms of commissioning further work. It was said on the 23rd that would happen and would need to in order to draw up what the route would look like.
One inference might be that the government didn't like the advice the expert group had given previously and was looking for a way out.
No, I don't think that's right or fair. I think the expert group themselves saw that their previous advice was ambiguous and were seeking to draw that out into something definite and clear.
Could we just go back to the first main paragraph again, please, Lawrence? And if we look at the penultimate sentence that's on the screen, where the group says we've been pleased to have the opportunity to consider these issues further, which we've done in light of the engagement meetings held by Sir Robert. Now, I was struck reading that at the curiosity of the group saying that they'd reconsidered this or considered it further in light of the engagement meetings. What you have is a group that had said, and I'm going to give this a kind of crude summary, yes, we can have the SCM in light of the engagement meetings that had been held in June. How that group can say now, let's not have the SCM, and still say it's in light of the engagement meetings, having consulted not one jot further. Is that something that struck you at the time?
I must say that's not how it struck me at the time or reading it now.
Well, let's go to page 15, please, where we see what's being said. And under that bold heading, it's the second paragraph, please, Lawrence. Thank you. And I'm going to pick it up in the third line. As the compensation scheme is based on clinical markers that will be accessible, accessible and verifiable, the group does not think it is appropriate or proportionate to require applicants to make personal life impact statements. Did it not occur to the government to subject that thinking by this group to some critical analysis? This was the opinion of HIV and hepatitis clinicians and a professor of healthcare law, not even psychosocial impact. Didn't it occur to the Cabinet Office that the right people to ask whether it's appropriate or proportionate to make personal life impact statements were the individuals who might be very happy to do so if it means they would actually get recognition financially for their condition?
So my reading of this was not, I heard the questions that you put to the Minister about this yesterday, and my reading of this was not that it was the intent of the group to disparage that. As the Minister said, that wasn't the intent at all, I don't think. And IBCA, as you pointed out, do ask people to tell their story, and rightly so. I think what the group was trying to say was that the process of people qualifying for this route should not depend on some kind of further assessment, but instead should be based on information that people could provide without having to be assessed by IBCA or someone on its behalf. I think that was the intent, rather than something different.
Yes, and I don't suggest it's disparaging. To my mind, it's somewhat bemusing that a group suggests and the government accepts something which is about let's spare applicants this without asking applicants what they actually think.
It's poorly worded, certainly, but I think its intent, as I say, is to try to explain that they've attempted to construct this route to build it in such a way that it does not require people to go through a further assessment to qualify, that they should be able to do so on the basis of records that they've already got. That is how I read it, but I acknowledge that it could be read another way, and in a way which I'm sure the group would not have intended.
Mr. Quinault, you in your witness statement, and it's your second statement, I don't at the moment think I need to put it on the screen. It's paragraphs 127 to 147 where you deal with this issue. I haven't detected in your statement anything which acknowledges that there has been a change of position and indeed an about turn by the expert group. If it would assist you to look at your statement, we can do so. Fine. Have I correctly understood? Your statement doesn't explain that there had been a change of position, does it?
So as I say, I don't think it was an about turn by the expert group. I think their original advice was ambiguous, and I think they cleared it up in this direction rather than the other. I think it is unfortunate. I acknowledge that the impact of that, having heard your conversation with the Minister yesterday, might have been that people would have been expecting one thing and then got another, but that was not the intention.
Look, as I understand it, it's one of the issues the Minister is going to look at again.
Indeed.
So I'll just ask one specific further question in relation to the SCM issue and then leave it. NTHT, please, Lawrence, 5059. And this is now dealing with the specific point about the severe mental health condition part of the Severe Health Award. You'll recall, Mr. Quinault, that for the severe mental health condition, you have to, as I alluded to earlier, have evidence from a psychiatrist of a diagnosable psychiatric condition falling within certain categories, and you have to have evidence either of inpatient treatment or of consultant-led secondary mental health treatment for a period of 6 months or more. Now, I think you've seen this letter.
I saw it yesterday.
Yes. I don't propose to read it out, but just to tell people this is a recent statement, 29th of April of this year, from the Infected Blood Psychology Service. And they raise concerns in this about how that can operate, because they say many people will never have seen a psychiatrist, and it's ignoring the historical and factual and context within which people suffered appalling consequences. I'm not asking you to communicate any formulated position on the basis of this, but is this statement from the Infected Blood Psychology Service something that the Cabinet Office can go away and look at? Because amongst other things, they say, at the very least, if you're going to have this as your scheme, don't make it limited to the input of psychiatrists, because most people will never have seen a psychiatrist.
So the Minister said yesterday that he would go away and look again at where the boundary between this severe health impact route and the core award is set, and whether we've taken proper account of that. We'll certainly look at this as part of it. As I read the letter, it welcomes the fact that mental health impacts are recognised in the scheme, but it questions whether the boundary has been set in the right place.
It does.
The intention is absolutely not to set the boundary in a place where no one could meet the test because of conditions at the time. And if it's wrong, as the Minister said, we will look at it.
Thank you. We can take that down. Thank you, Lawrence. I just want to ask again a couple of questions to try and help us understand if the scheme captures elements of suffering. And this is about affected people now. And the Minister, again, as I understand, has taken away the suggestion of opening up a supplementary route for the affected, so I'm not going to ask you about that. But does the scheme, on your understanding of it as it currently stands, account for or quantify the kind of suffering that some affected people underwent, including complex childhood grief, interrupted development and education, long-term mental health impacts for bereaved siblings and children, by way of example? Is that something which, based on your knowledge of the scheme, was captured in the expert group's advice, or is outside what the expert group considered?
The scheme is intended to compensate affected people for their own suffering as a consequence of this scandal. I think one of Sir Robert France's recommendations was that what was originally proposed for social impact was too low for the affected, and the government increased the proposed tariff in light of that. Does the tariff cover every individual circumstance? No, it does not. It isn't necessarily kind of broad brush, and that is why the Minister said he would look at whether there was some way of reflecting the full range of experience in a scheme.
And
the difficulty with the issue with a supplementary route for the affected, and this was the reason why it was not part of the government's original proposals, is that would have to cover a very wide group of things. It's difficult to see a way of setting tariffs for all of those eventualities. The alternative is something with a great deal of discretion in it, and although discretion would allow IBCA to consider the circumstances in front of it, it does have a downside in terms of possible delay, and so that is why the government originally considered whether a supplementary route was appropriate for affected, but decided not.
And again, if we want to try and understand and work out for ourselves what has been encompassed in the tariffs that have been set, we look to the expert group reports primarily, and then to the August publications from the government.
Yes.
Those are our sources, are they?
Yes, and in the particular instance I mentions also Sir Robert's original recommendations, where he explains the reasoning he went through to suggest that the social impact award for the affected was too low.
Now, I'm going to turn to, again, a number of aspects in the regulations, if I may, starting with the effective date of treatment for those born after 1961 and infected with hepatitis C. I don't think we need it on screen, but if we do please let me know. But it's Regulation 20 of the 2025 regulations. And so this builds in, as I understand it, an assumption that people were effectively treated for hepatitis C in 2016. And at that point, then, the amount of compensation for financial loss significantly reduces. Have I broadly understood it correctly?
Yes, with one small adjustment that the government acknowledges that not everyone would have been able to get access to that treatment as soon as it became available, and that is why the assumption is that, as it were, the year of effective treatment for the in terms of the scheme is a year later than the date it first became available.
Yes, and that has been clarified.
And one other small thing to mention, which is that the scheme also assumes that the reason why it's 1961 is because it assumes that for people who were over 55 at the time this became available, that it was effectively already too late for them to return to work, even if the treatment was successful and helped them. And so the scheme doesn't assume that their financial loss reduces from that point.
But what the scheme does assume, other than that age cut-off, which you rightly point out, is effectively that those who were infected with hepatitis C have, once they have undergone that treatment, and the virus has cleared, it makes assumptions about their ability to work. Now, the treatment may clear the virus, but it doesn't reverse liver damage. It doesn't treat symptoms such as chronic fatigue or brain fog. It doesn't treat the accumulated physical tolls of decades. So what is effectively halving, I think, the amount of compensation for financial loss is based on a false premise, isn't it, that people will be able to go back to work when they probably won't.
So it doesn't assume that after treatment, a person's ability to work, goes back to where it would have been but for what happened to them. There is still a reduction, but the reduction is smaller than before they had the treatment. In terms of liver damage, of course, for the more this is only the case if you're talking about the chronic ban for people at the upper end. It doesn't assume that for people with cirrhosis or decompensated cirrhosis, the assumption is basically that they can't work anymore.
Can I then turn to another aspect?
So I should say, as I did before, that I think the government would acknowledge that this will not be fully reflective of everybody's circumstances, but it's a broad-based tariff scheme. It needs to set some kind of assumption about what in broad terms people's experience would have been in order to move forward.
I'll turn to a completely separate aspect of the regulations now. The regulations require, and again for anyone who wants to know, it's Regulation 14.2c, that the application must be accompanied by evidence which establishes the date on which the diagnosis of the infection was made. Now, as I understand the scheme, that does have some relevance for some of the HIV calculations. For the position of those infected with hepatitis C, and this is the case whether it's transfusion or blood products, many were not informed of their diagnosis for years. Some were tested without their knowledge and not informed of their diagnosis. what's the relevance of asking for evidence of date of diagnosis, particularly as it may well slow down the process of assessment of their claims, because it's a search for a chimera which won't exist in the
So
records?
it's not relevant to the determination of a lot of the claim. It doesn't affect what happens to the injury or social impact or autonomy award or the award for care. Those are the same. They just depend on severity band under the same whenever you were diagnosed. Where it does make a difference under the scheme is for financial loss. So higher, as we've just discussed, the scheme pays higher rates of financial loss for people in the higher severity bands for hepatitis, and obviously you want that higher financial loss to be paid, from when it's properly reflective of people's circumstances. That's to say, as far back as they were suffering those extra impacts, and diagnosis is the attempt to capture a kind of marker for that. Now, I acknowledge that there will be many people who don't have that information. If they do have it, great, and the scheme can work on that. If they do not, this is where IPCA's ability to look at the balance of probabilities and other evidence comes in. There might not be a diagnosis, but there might be something in medical records that on the balance of probabilities makes it likely that that was the moment. Or if there's nothing, attestation that was the moment that someone, started to feel sort of particular impacts would do. Where this is particularly relevant, I think, is in claims from people from estates, where it could well be there is just no records of any kind at all, only a death certificate, and sadly, and that is where the deeming provisions come in. If no other evidence exists for those estate claims, the scheme will assume that they would have if they died of their infection, that they would have been in the top band for 4 years before that, and in the band below for 6 years before that.
We'll come on to the deeming provisions.
But in brief, that is the role that diagnosis is supposed to play in the scheme. But you're absolutely right that not everyone will be able to point to that, which is why the scheme has got ways of dealing with it.
It's not just the question of whether people can prove it. I, at the moment, and it may be my fault, I don't understand why the date of diagnosis, as opposed to the date of infection, is the relevant date for any calculation of financial loss. If you have someone who was infected with hepatitis C in 1985 through a blood transfusion, we know many of them, then they suffered the ill effects of hepatitis. They suffered them both in terms of brain fog, chronic fatigue, not knowing what was wrong with them, and being brushed aside by clinicians often. They suffered the impacts in terms of their liver. Some of them were not diagnosed for 20 years. They must be entitled to be compensated for that 20-year period. And
they are by the scheme, in that, as I say, from the date of infection, the financial loss is counted. The scheme assumes that right from infection, your ability to work, because that's what we're talking about here, will have been reduced to 60%. That is where the scheme attempts to capture those effects. But it's true, I think, that as people get sicker, their ability to work, they will be much less than that, and some may not be able to work at all. And that is why the scheme is attempting to capture that, and to give more financial loss for people in a higher severity band, but to do so, and to do that fairly, and to take it back to the earliest point that it should be being paid, it needs some kind of marker, and the marker is diagnosis, or where evidence of that can't be proved, something that can stand in place of that. So that's what it is. That's what it's for. It's attempting to make sure that people get paid for the financial loss they actually suffered, as far as this tariff scheme can do that, as far back as they should.
maybe I think we will need to come back to you on that in writing, Mr.
Happily,
Quinault.
I'm sorry if I haven't explained it clearly today.
It's not a matter which
Yeah.
we previously asked you to address in writing, and I think it may be helpful. I want to ask one specific question about the cut-off date of the 31st of March, insofar as it means that people whose husbands, wives, partners die after the 31st of March will no longer receive support payments. It's one question because the Minister again dealt with that and has agreed to take that away and look at it. I think I do need your statement on screen for this. It's your second statement. It's WITN 7755003, please, Lawrence, and it should be page 34. Paragraph 213. Thank you. So I've been asked to ask you what you meant here. You say infected persons who pass away after the 31st of March 2025 can, through their estate, make provision for a partner from their own compensation if they wish. That assumes that the infected person has received compensation, does it not? Which many will not have done.
That is true.
So, what exactly was the point you were seeking to make here?
May I read the rest of the...
Of course. Lawrence, could
section,
Mr. Quinault be shown?
The previous page, if I may.
Yeah, the bottom of the previous page, just to see it in context. So you were asked the question why people will not receive support payments after the 31st of March.
Yes. So,
And then if we go over to the top of the next page again, Lawrence. Thank you.
I think the point I'm making is to try to explain why the government thought it was acceptable to end that entitlement, and the point is that there is now a compensation scheme which pays compensation to estates, but also to bereaved partners in their own right.
And you will have heard the questions to the Minister in relation to this yesterday. I'm just going to leave you with the suggestion that there's a misplaced assumption there, because it doesn't address the immediate needs of the position of the person whose support payments effectively received by them as a couple are cut off. And of course, it presupposes that the infected person has received their compensation and can therefore leave it. Separate topic, multiple co-infections. So again, as I understand it, the scheme contains provision for co-infection with hepatitis B and hepatitis C. It contains provision for co-infection with HIV and hepatitis, and there's therefore I think Sir Robert described it in his report last summer as there's an uplift applied effectively.
Yes.
I don't think there is any further compensation or recognition for those who are triple infected, so they are infected with hepatitis C, hepatitis B and HIV. Is that right?
That is true.
And why is that the case? Is that just not something that was thought of?
I would need to check back whether we did cover that, but I believe it would have been because at that point compensation is already at the highest level offered under the scheme.
Well, I'm going to, if I may, again, leave that with you to go away and invite consideration of within the Cabinet Office with ministers as appropriate. Because although the numbers who are infected with all three may not be great, there are certainly some.
Yes. And
you will have seen, and I don't know if I need to put it on screen again, I won't at the moment unless I need to. You will have seen an email from a claims manager at the authority which deals with what's called an HIV liability window in the position prior to the 1st of January 1982.
I saw the email yesterday when it was...
And I asked the Minister about it. That's another matter he's going to go away and look at, and I think he understood the reasons and concerns which underpinned my questioning. So I'm not going to ask you about the substance of that, but just to tell us this, not least because it's a position that appears to find its way into Regulation 3 of the regulations. Is this a position that was identified by the Cabinet Office, that there's a significance of a date of the 1st of January 82? Did it come from the expert group, or does it come from somewhere else?
We are checking back as to where this came from, but my understanding is that it came not from the expert group, but from the Cabinet Office. I should say I had not seen that email before yesterday. Again, we are checking, but I know you asked David Foley and Sir Robert Francis this morning if this was something that, as it were, had been handed down to them from the Cabinet Office. As far as I'm aware, that text did not come from my team or from anyone else who works for me.
Right, well,
would not be reflective of the government's position on that.
Well, we'll look forward to a further explanation of that. Two further matters on the regulations, which have been flagged up in some of the statements from recognised legal representatives. Now, the first issue is an issue relating to Regulation 7. In the interests of not having to confuse everyone by the appallingly tortuous wording of the regulation, I'm not currently going to put the regulation up on screen, but again, if you need to see it, let me know. But you know the issue that I'm referring to. Mr. Harrison and I think Mr. Matthews in their statements have set the issue out. It's about how you calculate past financial loss. And if this were, for example, a court personal injury assessment, it's a pretty simple sum to do. You work out the right amount per year and you multiply it by the number of years. The scheme requires a calculation that's applied to the total financial loss figure and yields a lower figure. Why has the government introduced essentially this equation in Regulation 7, which has the effect of reducing someone's past financial losses if they elect to remain with the support schemes?
So, under the scheme the government originally proposed, the idea was to generate a kind of whole life figure for care and for financial loss, which broadly compensated people for the impact on them over a life, but did not try to attribute that year by year. And for care in particular, as you know, that doesn't really make any sense. It's possible to come up with a general pattern of the care people might require depending on the severity of their suffering, but not to say exactly how that would play out year by year. Everyone's experiences will be different. So the intent was a whole life calculation of those things. With the support scheme option, in order to make sure that the support payments, if that's what people choose, offset the future financial loss and care, but not the past, it is necessary to divide up those whole life proposed awards into an element that relates to the past and an element that relates to the future. I understand the point the recognised legal representatives are making, which is that if you do as the calculation does and take an average across the whole of that period, you are arguably underrepresenting the past loss, because that average also includes some years where people will be getting a pension rather than full earnings. And I think that is a fair point to make. But what I would say is I do not believe that overall this approach is disadvantaging people or is not fulfilling the government's promise to make sure that people's past compensation is not affected if they take the support payments route. The care award, which is cut in the same way, broadly speaking, most people's most expensive years of care are in the future rather than in the past. But this calculation averages those both in the same way, so that arguably there is the compensation is weighted towards the past. And of course, the calculation of financial loss begins at 16 as well. It assumes full earning power at the national average plus 5% from 16 rather than a later point. So for those reasons, I think it is not undercompensating people. It would be possible to do it would have been possible for the regulations to do as the RLRs suggest, and to take a different approach and to build up the financial loss award kind of year by year. But I think while that might have looked more precise, I don't think it would actually be more accurate.
Well, doesn't it mean that those who want to remain registered with the support schemes are financially disadvantaged?
I don't think they're being undercompensated by this way of doing it for their past loss, no.
Well, again, that may be an issue that the inquiry will have to determine for itself. And then the deeming provisions that you referred to, and this is Regulation 20, subparagraph 7 of the regulations. And again, I don't think we need to have it on the scheme, but you've explained why it exists, and one understands that there's a deeming provisions when one can't establish through medical records or otherwise progression through the levels of severity. But the regulation takes effectively as the starting point, as the relevant date, the date of the application to the scheme. And so let's say you've got someone who had a liver transplant in 2005, but doesn't know when they developed cirrhosis, so they can't demonstrate anything else. Shouldn't the deeming period be taken to be from 2005 applied backwards rather than 2025?
So where evidence exists, the scheme takes what evidence there is, and the point of the deeming provisions is to kind of step in if there is no evidence at all.
So is the intention, if in the scenario I've outlined, when it's known that the person had a liver transplant in a particular year, but it's not known what the progression of their disease was prior to that, are you saying that you don't start from the date of application then? Because that doesn't appear to be what the regulations say.
So in that case, you would start from the date of application, yes.
Doesn't that disadvantage people?
So I think where they have the evidence, it shouldn't do no.
Forgive me, I don't understand the answer, and it's not an easy provision to understand, but if the only piece of evidence is the liver transplant in 2005.
If there's no evidence at all, then the deeming provisions apply. The anomalous situation is where you do have some evidence. You've got evidence that people were at the highest, someone was at the highest severity band, and you have a definite date of infection or assumed date of infection. I think then there possibly is an anomaly in that the deeming provision can't, as the way the regulations work, can't provide for the kind of middle stage, if you like, as it would in the case of someone who'd an estate claim.
And that could potentially make a big difference.
Well, it would make a difference, but of course it only applies in the case of the highest awards, when people are already at the top end of what the scheme can provide. So I think there is an issue there, but it's not, it's small in the context of those larger awards. I think I looked at the issue that that Mr. Harrison pointed out. I think in that case, what we're talking about here is a significant sum of money, but it's about 3.5% of the total award.
Well, I think it would be helpful to have probably from you, first of all, is that something the Cabinet Office can look at again? Because I think you've accepted there might be an anomaly in some situations.
So I'm conscious I probably haven't given as clear an answer as I might. This is a complicated thing. If this is somewhere where it would be possible to provide a kind of fuller written statement, I'd be happy to do so.
I think it would, because I think you'll know that Mr. Harrison wrote to the Cabinet Office setting out his concern about those provisions, and you've got a very clear explanation in his statement as well about the position. And the letter he's received in response, which I think you've also seen, with the greatest of respect, doesn't answer the question at all. And so I think a proper answer to that question would be greatly of great assistance. Last question on the regulations. And if we're able to go for a few further minutes, so I think I can probably pretty much reach the end of my questions, and we can then have the break for call participants. Regulation 33, and I am going to ask for this one to go up on screen. So it's RLIT 0002944, please, Lawrence. Page 31. And so if we go down to the bottom of the page, please. So you see there, Regulation 33. And just one, thank you, that's perfect. So this is the supplemental route, this is exceptional reduced earnings. For the purposes of this section, an eligible infected person has suffered exceptional reduced PAY earnings if, as a result of an infection or any associated treatment, he has suffered a reduction in PAYE earnings because they can no longer perform work which is remunerated at the same level as the work they were performing before they were diagnosed with the infection, or work for the same amount of time that they could work for before they were diagnosed with the infection. So it's that phrase, before they were diagnosed with the infection, that I've been asked to raise by you. If you have someone who is infected as a child with HIV, notwithstanding that they manage to establish themselves in when they get to young adulthood in well-remunerated work that would otherwise be sufficient to bring themselves within this supplemental route, and they then develop AIDS and can no longer work, and I have a real-life case in mind when I ask this question, so that it's not just abstract. This would appear to suggest that they cannot make a claim because they cannot point to work they were performing before they were diagnosed with the infection. Now, there's some evidence, I think, that IBCA are taking, quite helpfully, perhaps a more liberal approach to it. But what is the Cabinet Office's position in relation to that? And does the wording of that need a little bit of amendment?
So I think that you could read that as saying that a person in the situation that you mentioned is sort of debarred from applying to the supplementary, which is not the intention. What IBCA are doing in practice is taking the peak of their earnings as the starting point for this, whenever that occurred, whether that was before the point of diagnosis or after it. They and the Cabinet Office have made clear in correspondence that is how this is to be interpreted. I'm very happy to clear that up.
Well, that's very useful. So essentially a purposive rather than literal approach to those terms.
Quite so.
Okay, thank you. My last topic then, I think, is lack of engagement or quality of engagement. Can I first just invite you to look at an extract from Sir Robert Francis's evidence in 2022. So Lawrence, it's INQY 1000224. And if we could go to page 36. And it should be, I'm going to try and find it. Yes. Very bottom of the page, so if we look at the answer, a question I put to him, and he was talking here about his proposals in the compensation framework study, and you'll see a question I raise, and this is bottom right-hand corner of the page, line 22. I ask him about a role for consultation with those infected. And he says this, definitely it's absolutely essential, and indeed you would probably expect me to say this as chair of Health Watch and president of the Patients, and if we can go over to the top of the next page, Association. They should be involved in the creative process, and this perhaps prescient observation, this is not an area where I would be terribly happy with 2 panels going away in private and coming back 6 months later with a proposed solution and having a 6-week consultation over the summer holidays to produce a result. You need some real involvement, as with everything else, but this scheme in particular, it needs to carry the trust of the people who are most deeply affected by it. Now that's exactly what did happen, except it wasn't 2 panels, it was 1, and it wasn't a 6-week consultation, it was a 3-week consultation. Was the Cabinet Office in the thinking it was doing in 2023, was the Cabinet Office aware of the view that had been expressed by Sir Robert?
Yes, yeah.
But it decided to ignore it?
As I say,
and to ask him to do, and this is absolutely no criticism of him, I should make clear, to do the very thing which he said shouldn't happen.
So I tried to explain in my evidence earlier how the government ended up in that position. I think, though I can't be certain that its intention was not to do that, but to consult on this over a longer period and more fully. But in the meantime, the date of the inquiry's final report, which the government had said it wanted to wait for, had gone back, and a deadline set in by Parliament in legislation to have a scheme established in law had come forward. And that is why the time available for doing this was very truncated and not, I think, what certainly not what had been thought of when planning for this was done. I said in my statement that I regret that, and it is certainly not what I thought would happen when I was first involved in this, and it was worse even than Sir Robert says here, I must acknowledge, because not only was it happening over the summer in a very truncated period, but it was also happening over an election campaign, which meant that there were things that we as civil servants could not do to support this exercise. Normally, you would expect the government doing something like this to publish a much fuller account of its intentions than it did on the 21st of May, in order that people could see and answer for themselves the sorts of questions that you were putting to me earlier about what are in these tariffs and so on, what account does it take of my circumstances. But instead of publishing something for everybody, what we had to do because of the election campaign was to produce an unpublished document shared with people attending meetings with Sir Robert, which we hoped they would be able to circulate widely to others who needed to see it. But we were not in a position to do that directly ourselves. So I just wanted to say I think it was even less satisfactory than the description you give, if I may.
We can take that down, thank you, Lawrence. You've said in your statement that the infected and affected communities have had a major influence on the design of the scheme. I'm not going to ask you to go into specifics now, but unless I get follow-up questions. But I just want to understand, when you say they've had a major influence on the design of the scheme, are you talking there essentially about the June 2024 exercise and the 69 recommendations?
That is part of it. I say this notwithstanding everything I've just said about the unsatisfactoriness of that consultation. That's part of it. I think there have been changes to the scheme since, in light of engagement, and I set out what some of those are in my statement. I think the other point I was trying to make was that the government does think that the scheme as proposed, is grounded on and based in Sir Robert's original compensation framework study. That was what the expert group were instructed to take as their starting point for their recommendations to government, and that, of course, did get some proper engagement and consultation with the community at the time.
I think it must be very clear to the government that the way in which the scheme has been designed and set up does not command trust and confidence, and that there is a lot that would need to be repaired, if repaired it can ever be. How does the Cabinet Office propose to try and address that?
So we must consider further, and whatever the inquiry may have to say about this will be will be vital to that. But I think we already know. No one hearing the evidence of yesterday morning could not know that this is not won trust and confidence of the community. I think there are a number of things we do, but I think the most important thing is to look again at the points that people are making about the scheme and on which they don't feel heard, and to see whether, as the Minister said, something can be done about those that doesn't fall into the other trap of leading to further undue delay when people have waited so long.
Thank you. So I think that's probably the right point in terms of my questions to end. So if we take our afternoon break, but that is also now the break for core participants to suggest to me further questions for Mr. Quinault.
Well, I suspect you'll probably need at least half an hour, will you?
I'm fairly confident I'll need the half an hour.
So shall we say no earlier than, it may be later, no earlier than 20 to 5 p.m.